So good evening and welcome everybody to Australian Medico Legal College's webinar on recent local changes to motor vehicle accident IMEs, independent medical examinations. We're highly appreciative that MedDirect, Sue and her associates, has again assisted AMLC to provide tonight's webinar. As Sue just said, we have a large number of viewers tonight, indicating the level of interest in tonight's topic. 3¼ years ago, legislative change in New South Wales regarding motor vehicle injuries affected how we do independent medical examinations. Last month, as it so happens, there was another change in New South Wales legislation regarding both motor vehicle and workers' compensation injuries, with the formation of a new Personal Injury Commission, known as PIC. However, those changes don't essentially alter the way we do IMEs. Not particularly, as the Personal Injury Commission is still reviewing the impact of those most recent changes. Today's discussion will only focus on the changes that occurred 3¼ years ago, as they're far more relevant to doctors who undertake IMEs. For the first 3 minutes or so, our panelists will discuss the administrative changes that occurred in December 2017, as they affect the types of questions that are now asked of IME doctors. However, we'll then discuss the more difficult, but for us, more interesting issues that affect IME doctors, including what do the new terms minor injuries and non-minor injuries actually mean? Is an annular fissure a minor injury following a motor vehicle accident? How long does it now take us to perform an IME assessment if we want our reports to be reliable? And we'll discuss the background and preferred training of IME doctors to forensically comment on things like causation, earning capacity, and domestic assistance. The panelists will also clarify the difference between the terms soft tissue injury, a minor injury as we'd normally understand it in a clinical sense, and the specific term minor injury as it's used in the new legislation, which is specifically directed to assess if an injury would normally fully resolve within 26 weeks. They have different meanings, those three sets of expressions, and that will be discussed tonight. During tonight's webinar, we'll be posing 3 separate poll questions to all of you, to the viewers, and we believe that your responses will be of particular interest not only to all of us, but to other parties who are involved in personal injury assessments. Australian Medico Legal College thanks our panelists for their time, and we look forward to hearing their experience and suggestions. The panelists are Clarence Brown, who's manager of the Motor Accidents Insurance Regulation Division of CIRA, Dallas Campbell, who's the senior lawyer and manager of the legal division of Suncorp's CTP division, Suncorp Insurance, Tim Concannon, who's the accredited who is an accredited Law Society specialist in personal injury law and a partner of Carolyn O'Day Lawyers. Tim was a CARS assessor for CIRA, that is a decision maker, from 2004 until February 2021, a month or so ago. Dr. Sophia Lars, who's a rehab physician and who's been also a CIRA review panelist for a number of years, also until just last month. Myself as the co-chairman of the Australian Medico Legal College's Education Committee. And we're very fortunate, Sue, we're very fortunate to have as our facilitator, Sue Larson of MedDirect, who as usual has committed a huge amount of time and effort into compiling this webinar. If any of you request information or have an interest in joining the Australian Medico Legal College, which is an educational college, our email address is info@amlcollege.com.au, and that email address will also be on your screens at the end of tonight's webinar. So thanks, Sue, over to you.
Thanks, Richard. So we certainly have a number of experts assembled on our panel this evening, but there are some also things that we would like to put to you and to gain your opinion on. So as Richard mentioned, we will be putting a number of questions to a poll to gain your perspective on different subjects tonight. Also, if you have any questions that you would like to ask our panel of experts, please feel free to do so. As is usual with these webinars, the time will be very tight, but as we go through our topics, if we have the opportunity, we will answer some of the questions live. If not, we'll follow up after the webinar to ensure that your questions are answered. Now, just a little bit of housekeeping. If you would like to ask a question, there is some Zoom functionality that I'd like to show you. If you move your cursor down to the bottom of the Zoom menu, you will see a menu bar pop up that looks a little like the one that's on the screen now. If you click on the button labeled Q&A, and you can do so now, this will open a question box that looks like this one on the screen. And you can then type your question in the box and our panelists will be able to see that and be able to respond, assuming we have time. We will collate the questions and we can answer afterwards if we have no time. The second piece of functionality that I'd like to draw your attention to is the chat box. Again, if you scroll down to the bottom of the Zoom menu, the menu bar will pop up. And if you click on the icon on the screen that says chat, the chat box will then appear, and that looks like this one on the screen now. So please use this if you have any questions that you would like to, or any comments, I should say, any comments you'd like to share with other participants on the webinar tonight, or if you are having technical difficulties. We do have a number of team members, tech people who can be on hand to support you and can help get you back online. So if you have any issues at all with tech, please put it in the chat box. Any comments, put it in chat. And if you have a question, pop it in the Q&A. So let us get started now. Now, Clarence, to begin, it would be helpful to understand the important milestones within the Act and how these determine the injured person's journey through the claims process. Could you run us through this, please?
Yeah, sure. Thanks, Sue. And it's good to be with you and the participants tonight. So the 2017 Act for the CTP scheme is sort of divided in two to some extent. You've got a statutory benefits model combined with a common law damages model. So with this slide on the screen, the top level of that slide is really the journey for the statutory benefits side of the claim. And those statutory benefits encompass both treatment and care and income support for those people who are income earners before the accident. And basically, I'll highlight the key parts is that at 26 weeks, that's really the first key milestone of the scheme. There is a 13-week step down for income support, but the real critical one is at 26 weeks. Basically, up until that point, benefits are paid on a no-fault basis, right? So anybody who's had a motor accident can access their treatment and care, and if they're an income earner, income support. At 26 weeks, if you're at fault for the motor accident, your statutory benefits then end. And if you've also only had minor injuries as a result of the accident, your treatment and care and income support will generally end. There's some exceptions, but that's the general rule. The other couple of key milestones I'd point out on that top slide is there's a 20-month milestone, which basically says for people who have under 10% permanent impairment as a result of the accident, they have to wait that 20-month period until they can make a damages claim. The 2-year milestone is really the end of benefits, income support benefits for anyone who basically doesn't go on to make a damages claim. And then there's a 5-year milestone that is quite important as well, because at that point, if you are continuing to claim treatment and care, you'll go to actually be managed to the Lifetime Care and Support Authority instead of the licensed insurer. And also income support benefits end there. So treatment and care will actually go on for life, but you'll be managed by the Lifetime Care and Support Authority. And I just point out there that you're not actually under the Lifetime Care and Support scheme, which some of your participants will be familiar with is a scheme especially for catastrophic injuries. It's actually a separate scheme, but run by the Lifetime Care and Support Authority. And I'll just speak briefly to damages. As I said, if you are under 10% whole person impairment, then you have to wait the 20-month period before you can make that claim for damages. And of course, you can't be at fault for the accident. But if you're over 10% whole person impairment, or the damages claim relates to the death of a person in a motor accident, then you can claim damages from the start. And there has been another change to damages under the 2017 scheme, which is that you can't get treatment and care benefits now as a lump sum in your damages claim. They're always going to be paid as a statutory benefit. And I guess that's the mechanics of the scheme design, but I just make a couple of general observations as well about this, is that one, all these elements of this scheme design is really to encourage the recovery of people and the return to work. So moving from, I guess, a dedicated lump sum compensation scheme under the 1999 Act, we've moved into a system where people can get access to treatment and care directly after a motor accident on a no-fault basis. And that's, I guess, a critical policy change. And the other observation I'd make is that in terms of the progress of how this scheme is going, we're probably only about 60% of the way through the scheme's maturity for the first accident year. So when you look at some of those milestones that are up on the screen, particularly say the 5-year mark, say if you're thinking of accidents that happened towards the end of 2018, those people are still working through some of those longer term milestones, and we haven't yet reached them on the scheme. So there's still quite a bit of time for the scheme to fully develop and to see the outcomes of all those kind of damages claims and also statutory benefits claims, some of which will continue on for a very long time, given that treatment and care is for life.
So lots of changes there and still very early days in terms of understanding how the scheme's performing. Dallas, I'd like to turn to you now with a question from an insurer's perspective. How have the information requirements or the expectations of IME consultants shifted from the old scheme to the new scheme?
Thanks, Sue, and hello, everyone. The fundamental changes that I've observed is that in the old scheme, historically, when a claim was made, it was an element of uncertainty of the amount of damages or what damages were payable by the insurer. A lot of precedent letters were sent out to doctors to what I like to describe as cover the field of potential heads of damages. There were questions around earning work capacity, whether the person could go back to work or perhaps be employable in the future in the open labour market. There were certain questions around gratuitous care and whether the person was unable to do certain activities of daily living, future surgery, future rehabilitation, future analgesics and the like. So there was a lot to cover at a very earlier stage from a medical point of view in terms of trying to assess the claim. Fast forward now to 2017, as we've got now, as Clarence pointed out, the statutory benefits model and the common law damages model. They have sort of separated the core issues, as I like to call it. And because the scheme is very heavily focused on early rehabilitation and early treatment payable as soon as possible, particularly for statutory benefits, the questions are now limited. So it's about diagnosis of the injury. Also, the big gatekeeper is whether it's a minor or non-minor injury. So the questions now addressed from a doctor is limited to those issues. So, for example, as the claim approaches the 26-week mark, fault might be an issue, it might not be an issue, but from a medical point of view, the minor or non-minor issue will be largely in focus. And because of the immediate effect it does have on entitlements to weekly benefits and treatment and care, a report will be required very quickly. So it's a discrete issue.
Thanks, Dallas. So with all these changes, to what degree are you seeing the changed expectations being applied in the reports that are being completed under the new scheme?
Yeah, as things chug along, I think old habits die hard. There's still a lot of, especially from the insurer's point of view, a bit of the same pro formas that seem need to be tweaked and readjusted. We're still firing off a lot of letters of instructions that are covering the field, so to speak, and in response we're getting those answers. But I also am seeing doctors that are that are just falling into that sort of practice of trying to cover the field and answer questions that are not limited to whether it's a minor, non-minor injury, whether it's a whole person impairment, or whether it's a work capacity.
Okay, so do you feel that medical assessors are providing too much information in their reports from what you're seeing today?
Yes, they start. Yeah, that's right. There's just that tendency to venture into other potential heads of damages or medical questions that aren't necessarily relevant to determine whether the insurer should or should not be paying statutory benefits.
Right, okay. Thanks, Dallas. So Tim, what makes a good report under the new MAIA scheme compared to the MACA?
I think it really depends on the nature of the dispute the assessor is dealing with, Sue. If it's a minor injury dispute, then I agree the crux of the report is fairly narrow. One has to stick to the definition, and it's a relatively modestly complex report. However, if you're looking at a damages claim, I think the importance is on having a report that can be seen as being objective as possible. And really, if you have a look at the new expert witness code of conduct under the PIC 4, which is now required to be acknowledged in all reports in matters before the Personal Injury Commission, then it emphasises the need for assessors not to be advocates of the parties, which I'm sure most assessors would already be aware of with the expert witness code of conduct under the Uniform Civil Procedure rules. But I think the emphasis now I've found, I almost invariably in damages claims try to reach agreement with insurers on joint medico-legals. That's for a number of reasons. One, the level of the regulated report fee, which can't be contracted out of, is very low. It's around about $1,600, and there are a lot of specialists who just will not see many claimants at that level of report fee. However, if it's a joint medico-legal report, the level of the regulated fee goes up to about $2,200 or $2,300, I think. If you've got multiple reports from multiple different areas of specialty, then that's a very key consideration to particularly if you're acting for a claimant. So I find, unfortunately, Dallas, I've found that the joint medico-legal letters that I get from insurers still canvass almost any and every issue, despite the restrictions on what we can claim under the damages scheme. I still find that there are any number of issues that I would have thought are largely irrelevant to damages claims that are still getting raised in the letter of instruction. So I don't think it's probably the medical assessor's fault that they're responding to those queries. I do think that treatment still has some relevance under the current scheme, not directly in the sense I agree it can't be claimed, but it does have relevance to how long the person's going to be off work, what level of deterioration is likely into the future, and issues like that. So I agree that care really, unfortunately, becomes irrelevant to a vast majority of claims unless there's a treatment dispute dealing with care. But I think the key for most medical assessors under this current scheme is really not to be seen to be an advocate of either party, but to really provide as objective an opinion as possible. And that's emphasised, as I said, in the expert witness code of conduct and in both the PIC and in the district court, I should say.
Right. Thank you, Tim. And if any of our participants tonight are unsure of what that expert witness code of conduct is, please feel free to reach out to the AMLC or to myself, or of course to Sarah. Now, Tim, you did mention a topic that is no doubt top of mind for a lot of our participants tonight, and that is around fees. And indeed, many of our medical assessors feel that the fee paid to deliver a reliable opinion isn't commensurate with the comprehensiveness of the investigation that needs to be undertaken, with the information requirements of the report, and indeed the volume of the documentation that can be provided, sometimes up to 2,500 pages. Then to add further context, while we acknowledge the scope of the questions asked under the new Act may indeed be a little bit more narrow than under the old scheme, many assessors believe that the investigative work that's required to make the accurate diagnosis and to determine if the injury is pre-existing or accident related in order to answer those questions hasn't really changed. Therefore, the requirements of the medical assessor in reality is no less than under the MAIA. Now, in terms of fees, Tim, absolutely $1,600 to $2,283 plus GST are the fees that we're referring to, and that is different depending on whether the assessment is a jointly appointed assessment or not. So Clarence, I'm going to direct this question to you, if I may. What is CIRA's position on this? And is there any discussion around reviewing the fees that are paid to medical assessors?
Yeah, I mean, it is, I'll address the second part of your question first, which is that, yes, CIRA does intend to, do a review of these fees, but it would be across both workers' compensation and CTP. That's planned for some time this year. But I guess in looking at the first part of your question about what CIRA's position, I mean, I think from my perspective, I guess what I'll do is I'll highlight some of the considerations for your participants that some of the thought processes that CIRA might go through when looking at these kind of issues. So for instance, as sort of a factual history basis, like when these fees were first regulated back in 1999, the maximum fee set under the regulation was actually $540 for a medico-legal report by a non-treating specialist. Now, currently, I guess if you look at the $1,660 figure in present day value, that actually reflects a 5.5% compound annual growth rate. I see Tim shaking his head there. Do you want to jump in there, Tim?
Well, because there was no prohibition on contracting out at that point. It's a completely different playing field with respect. I mean, if you can contract out, if the report costs you $1,700, unfortunately, the claimant's bearing the gap between the 500 and the 1,700. But there's no option to do that these days. If the doctor won't accept the regulated fee, then you don't get a report from them.
Right. Yeah, but we are talking about the regulated fee at the moment. So I think what you're talking about is a separate issue about contracting out.
No, it's not. It's that they're all involved. They're all interrelated. If I can contract out, I won't mind so much if a report fee is $500 and I've got a damages claim worth $500,000. If the value of my damages claim is significantly limited by the fact I can't claim medical treatment and care, and I can't contract out of the $1,660 or $1,630, it's an enormous difference to what's clear in the hand to the claimant at the end of the day. I just don't think you can compare the level of the report fee in a regulated area, in an area where you're allowed to contract out, to an area where you can't contract out of the regulated fee anymore.
Well, I do. I take your point on the issue about the interrelated nature of it, but I guess what I'm addressing is at the moment is the regulated fee as keeping its value over time, right? So in that context, there's been a 5.5% compound annual growth in that figure. So I think that the regulated amount has kept that value quite faithfully over time. Now, on the issue of, now you might say, well, let's look at other jurisdictions around the regulated fees. And if you look at the workers' compensation system in New South Wales, you're looking at round about the same fees. If you look at outside New South Wales, say you look at a comparative jurisdiction like the TAC, the Victorian CTP system, their regulated fees are around $1,400 to $2,200. And it's similar to, again, what you get in New South Wales with if you take the joint medico-legal fee into account. And I'm actually pleased to hear Tim's experience with joint medico-legals and the fact that that the deliberate attempt to provide the higher fee for joint medico-legals does incentivize people in perhaps the more complex cases to seek a joint medico-legal because it has that extra budget allowed for. I mean, that's there for a reason, to incentivize joint medico-legal. And I think that operates at two levels. It operates on giving that extra bit of budget, but it also operates at the insurer level because there's a very easy mechanism for claimants to recover the cost of the medical reports they get. So from an insurer perspective, why would you pay two $1,600 amounts? It actually makes more sense to do a joint medico-legal. And I also think in the context of doing a joint medico-legal, you're probably in a better position, as the conversation with Dallas and Tim alluded to earlier, to have a conversation about what's actually relevant in that referral and whether that can be refined and perhaps narrowed to only the issues that really will get you the value from that medico-legal opinion.
So I think there's no surprise that this particular topic is a bit of a hot topic, and certainly we'll go to a vote a little bit later around the fees and whether they are actually commensurate. And I guess, Tim, that the point you're making is if the fee is not strong enough, then doctors will not contribute to the scheme. Clarence,
Well, if you have a look at the list of authorised health practitioners on the CIRA website, you can see that in certain areas there are just very few doctors on the list. And I hazard to guess that's probably because they don't think it's worth doing reports anymore. I don't know whether Sophia has any particular views on that. But neurologists, for instance, I think there are less than 3 or 4 on the list. Rehab doctors, I think, is a similar situation. It's
yeah, the fees for the more complex injuries such as spinal cord injury and traumatic brain injury, it's just not worth it.
I've had discussions with a number of doctors about those issues, and particularly dealing with brain injuries and spinal injuries, and I deal with a lot of those cases. And I just find that unless the doctors are doing me a favour, they say they budget for one of these a month, and that's about it. The well-known rehab and neurologists or neurosurgeons, and just they can't afford to see people regularly. It's $1,630 a report.
Dallas, what's your view on this matter?
Yeah, look, as Clarence alluded to, it's in my view, it starts with narrowing the issue, getting to the core question that's being asked. And I think there is an onus on the parties, particularly if they are arranging the joint medico-legal report, to tailor the questions to the specific issue. But I do think that which I only recently just found out, that the contracting out provisions will skew and limit the availability of suitable experts to these particular issues. I do believe that.
And I think certainly there has been that experience in other states and schemes as well that have been fee related. Let's go to a vote. We'd like to get... Sorry,
I thought I had a comment or two to make on that as well, if I may. In fact, I've got quite a bit because of some of the things that have been brought up. First of all, just to clarify something that was stated before about statutory benefits versus damages, I heard your explanations, and just as listening from a doctor's perspective, I'd just like to clarify, because I would imagine a number of doctors wouldn't have picked up on the subtleties of what was being said. As I understand it, statutory benefits now means you can't claim treatment as a part of the lump sum claim at the end, even if lump sum is going to be available. It's now only payable as necessary. In other words, as the requirement for treatment comes up, the insurer has to pay it as necessary, and it can't be looked at as what are going to be the future treatment needs and paid out as a future lump sum. That's a very big change. That's one of them. The second one is domestic assistance. There used to be domestic assistance available, even gratuitous domestic assistance, which means your spouse or your child or somebody, your relative, can come and do the cleaning, and that person will be refunded for the effort and time that they put in. That's no longer available, as I understand it. Please correct me, panelists, if I'm wrong. This is important for us as doctors to actually understand these differences, because domestic assistance was an important request previously that is no longer available as a gratuitous payment if it's necessary to have a paid organisation coming in to do cleaning because of the identified injuries. then that's still acceptable and claimable. But that's again under what you're referring to as statutory benefits. That is, you pay as you go, and it can't be seen as a future lump sum necessity. So that's a big difference in terms of what's asked of us. Whereas damages is a whole series of other things that always were damages. That is, it can be converted to lump sum under certain circumstances, which the other panelists have talked about. But this topic of the fees is a really important thing, because Clarence mentioned that there was a start of $500 something at one stage. Clarence, that's only relevant because nobody stood up and said, this is ridiculous, we won't do the cases for this amount back in the 1990s, because it was actually never enforced in the CTP division. If it had been, then there would have been a significant dropout of people doing the work. So to use that as the baseline implies that we were all okay with that fee at that time, and it would not have been. It's just that nobody really stuck to it, neither the plaintiff nor the respondent referrers or the doctors. So that's a really important point. And another issue here is that we're talking about motor accidents, not workers' comp, and there's a huge difference, because commonly workers' compensation is about a single injury, whereas in motor vehicle accidents, as we know, there are multiple injuries in many cases. So we can't really even compare the fees of workers' comp to motor accident, because commonly we're looking at a number of injuries and how each injury is compounding the other injury as well. So it's a very big difference that we really need to look at. The biggest issue is something that Sue raised in the introduction here, but I do really want to highlight this, that Dallas has said that there are only a few questions now that are necessary in most reports, and that's correct, of course. There are less questions, less areas to be addressed. But as the IME doctors know, if we're going to be doing this job correctly, our role is to confirm or refute the claimed information that came maybe from the treating doctor and or the claimant and or the claimant solicitor, etc. That the role is to confirm or refute it, and the opinion should be the same. Doesn't matter where the referral came from. If the referral to me as an IME doctor came from the insurer or the plaintiff's claimant solicitor, it's irrelevant. Our job is to confirm or refute information that's already there. The answering of the questions has always been the easiest part of any IME report for a skilled and experienced IME consultant. The hardest bit by far is unaltered as to whether there's one question or four questions is not the issue. The issue is really the coming up with the diagnosis in conditions that most commonly have few or no objective signs. So it's the skill of the diagnosis, not the questions. That's the difficulty of doing any IME report, and that takes the great bulk of the time, because part of that also is assessing causation to confirm or refute that the claimed injuries, if they are present, were caused by that motor vehicle accident, in this case for CTP. That's the big effort. So altering the number of questions is something that the administrators and lawyers will see as being reduced work, but the doctors really don't. So even with a single question, we still have to go through the difficult situation, which sometimes can involve looking at hundreds or even thousands of pages of documents, because there's been a past history of similar conditions and trying to exclude. So there's the causation that takes the time, and the diagnosis in conditions which traditionally, most commonly, have few signs. That's the big time. So that was the introduction to the poll, because of the wording of the poll is also as wordy as I've just been now, for a reason, because the wording of this first poll that Sue is going to put up is all the things that we should always be doing for every IME, whether there's a single question or multiple questions being asked of us. So this is the first poll.
Can I just say, before we go, or go to the poll, but I just wanted to say a couple of things in response to things Richard said. Is just simply, I understand the argument that, the baseline, you can argue about the baseline, whether that was set at a correct amount, but I guess then you also do have to do a bit of a comparative analysis with other jurisdictions around Australia, like jurisdictions. They also end up with around the same figure. So I just want to emphasize that it's not just a New South Wales issue here, you know, on the baseline question. And secondly, these kind of matters I'm raising now are things to give the participants an insight into some of the considerations that CIRA would take into account when it's formulating its view. So I think it helps for anyone who would happen to make a submission, you know, at a time when the opportunity arises, to get an insight into how we think. If we're transparent about that, then, you know, you've got an opportunity to better formulate the way in which, you know, you may make a more persuasive submission.
And you're right, Clarence, absolutely right. I will advise you that I go to many medical conferences, interstate conferences. The hottest topic by far is this one in every state, that the doctors, IME consultants in every state are screaming about how the fees have been markedly reduced over the past several years, to the degree that so many consultants are just saying it's not worth their while doing it, as Sophia implied. So you're right about the other states. The other states are also having the same problem. The doctors are having the same problems there as we're discussing here today.
All right, so let's go to a poll now. You've all had the opportunity to read the question on the screen. So without any further ado, I'm going to launch the poll. And of course, I'll welcome some final comments from our panelists once we have received the results. So I'm launching the poll now. Please just take a moment to submit your vote. A lot of people weighing in on this one, obviously. We're up to about 60% have voted. All right, just for the last couple of seconds, please submit your vote to the question. All right, I'm going to close the poll now. And you should see the results on the screen. Can you see that? Can you all see the results? Mm-hmm. Fabulous, thank you. Okay, so I'm just going to put it back to our panelists. We've got obviously some interesting data here that reflects the typical experience of our IME consultants, sitting at around 4 to 6 hours to prepare, read, investigate, examine, write, edit, etc. No doubt this will form the basis of some meaningful conversation that still needs to be had around the issue of fees. Would any of our panelists like to comment on these results?
I'll comment if you like. Certainly with the DRS assessments, I've never been able to do one in under 4 hours. Mm-hmm. So 4 hours is my absolute minimum. I find typically I'd probably be in the 4 to 6 hour bracket. One of the issues is the documentation, very messy, quite often very poor photocopies, photographs, you know, using an iPhone of documents, poor clarity. That makes it time consuming, then having to go back to the authority to ask for documents that can actually be read. Sometimes not having any documents pertaining to the, you know, the claimant's complaints immediately after the accident, which is obviously a key thing to determining causation. So yeah, I think there's a few, you know, practical issues there. Documentation varies. I mean, sometimes, you know, it can, I found at the beginning of the 2017 scheme, it was, the documents were more contained, you know, shorter. And as time has gone on, I've found the documents have become larger and larger. I don't know exactly why that is. But yeah, I think it's impossible to do a good job with these in under 4 hours.
Would anyone like to respond to that comment?
Yeah, I can. I agree. I think it's incumbent on those requesting the reports to make sure that not only the right questions are being asked, but also the relevant material. I mean, unfortunately, I have seen situations where slabs and slabs of potentially irrelevant information has been sent out without any consideration to what the question is being asked. So I agree that is a problem. But just looking at the think it was 33%, 4 to 6 hours. If my maths is correct, what's that per hour? That's $300 to $400 per hour. Is that the sort of standard rate across the industry for what?
Clearly not.
No.
No professional.
The DRS fee is $460 per hour in the new scheme, and actually for a DRS report, it's currently funded at 3 hours. So pretty well every time I was doing one of these reports, I would have to actually ask for additional time.
Yeah, it falls short.
Falls short, yes, it falls short against most professionals, not just doctors, but most professionals. And I specifically created that question to say for an average motor vehicle accident, because I didn't want it to be biased one way or another. But obviously, average does not cover the really difficult cases where we often do, where the referrer really does need to have much more information and time involved. And so the sorts of cases, for example, that Sophia was talking about, the major head injuries, etc., but also multiple injuries, are not average. And the fees that are currently in place don't go anywhere near covering the slightly above or a lot above average cases.
And this disadvantages the more, the more seriously injured people in New South Wales who we should be protecting and providing, decent reports about.
Correct.
A further question actually from one of our attendees, which is around, what should the charge therefore be? And maybe Clarence, I'll ask you to comment on this. But around, should given the number of hours that on average most of our participants seem to be spending on these reports, should they therefore not all be billed as complex rather than standard or moderately complex? Does such a fee exist for clarification?
Not in the New South Wales CTP scheme. It's not linked to complexity. I mean, you've got a range up to a maximum, and within that, that's the fee.
Yeah, we've only got a maximum fee, that's it. And yes, so it doesn't.
There's a range in workers' comp matters.
But even the complex in
moderately complex and complex, yeah.
Yeah, but it goes up to the equivalent of what CTP is for a complex.
Yeah, it's not dissimilar.
Yeah.
Yeah. All right, so let's move on. I'm conscious that many in our participants tonight are also very keen to look at the definitions and how to apply the scheme to medical medical injuries. So we're going to move on now and start to look at medical assessments under the MAIA. Whether a person has a minor injury is central to their rights in both the statutory and common law damages schemes. Tim, can I ask you, why is this such a friction point now? Why is it so important at this point in time?
Well, it's
and
critical.
I have the definition on the screen as well, for those of you who'd like to refer to that.
Well, it's critical to both statutory benefits and to common law. Statutory benefits, because if you've got a minor injury, you effectively don't get any weekly benefits nor medical expenses, subject to those limited cases that Clarence outlined earlier beyond 26 weeks, and you can't bring a common law damages claim. So it's the absolute no-brainer. It's the one test that's critical to the functioning of the scheme. I think there are problems with the definition, and I think one of the key problems is I think that the first part of it refers to an injury to tissue that can, this is subsection 2 that you can see there, to tissues that connects, supports or surrounds other structures or organs of the body. Well, I would say what happens if the injury is not to the tissue that connects, supports or surrounds other structures, but it is to the organ of the body itself. And I would say that, and I know CIRA in their minor injury report takes issue with this, that any part of the body that's an organ, such as, let's say, the skin, the brain, or the eyes, any injury to those parts of the body can be, by definition, not a soft tissue injury. Then you've got to look at the last bit, which is the one that I think becomes controversial, in particular in spinal injury cases. That is paragraph 2 there, but not an injury to nerves or complete or partial rupture of tendons, ligaments, menisci or cartilage. I think that's a problem dealing with cases such as, I think Sophia will probably talk about this a bit later, but annular fissures versus disc protrusions. At what point does something become a complete or partial rupture of cartilage, having regard to the way the disc in the spine is constituted? I think some doctors have struggled with that definition and how it can apply, for instance, to an annular fissure, which can be present in both younger and older members. And particularly, I think the issue that a lot of doctors have grappled with is the extent to which an annular fissure can be, I think they accept that it can potentially be a complete or partial rupture of a cartilage, but did it in this particular case cause a rupture of the relevant cartilage, having regard to the person's age, and that can become a very controversial issue.
Yeah, and we'll discuss a number of those with a little bit more depth moving forward. We've got a lot of curly questions for Sophia for sure. Before we move into Sophia's curly questions, Clarence, we've got some early data, obviously, showing the main areas of dispute around minor versus non-minor. Are there particular injuries that are proving more prone to dispute?
Yeah, well, as Tim alluded to, CIRA did do a review of the minor injury definition, and that's available on our website. It was released in February 2020. And one of the findings of that was that, spine injuries generally are probably one of the more contentious areas, and do appear to have, a higher, overturn rate when it goes to dispute. And when we looked into some of those cases, I mean, it's the fact of injuries around that area of the body are just a bit more difficult. They require, they're a matter of clinical judgment as to whether some things are due to a motor accident. It's that causation issue, whether due to the motor accident or whether there's some other cause, like just, degenerative changes in that area of the body. So because it is a bit of a judgment call, you're going to have situations where it's more likely that reasonable minds might differ on that point, depending on how they look at the evidence.
So we're going to turn now, thank you, Clarence. We're going to turn now to Sophia and some practical examples. Obviously, as a DRS, for many years, you've seen a lot of complicated presentations, and there is some level of confusion around the application of these definitions, minor versus non-minor. And I'd like to thank all our participants who are writing in comments in the chat, and for your questions, please keep them coming. I'm tracking these and we're answering these as we go. So thank you for that. Sophia, where do you see specific challenges in distinguishing between minor and non-minor injuries?
That's a very big question. I take Mr. Concannon's point that he made about the difficulties with having a definition that really mostly refers to soft tissue injury, but when we're referred injuries of the brain, for example, and organs. Just to give a very brief example, we did have a claimant who challenged that because this was a woman who I think did not have a traumatic brain injury according to the definition, but had a minor, head strike on a headrest soft tissue injury, who had all kinds of visuoperceptual, mostly sort of visual problems, dizziness and headaches after her accident. And the assessor found that I think he diagnosed a concussive injury and said that there'd been a sort of an alteration in brain function, but went on to find that it was a minor injury. And the claimant, who was an educated person, came back and said, well, how can it be, if my brain's not functioning properly, how can that be minor, and how can the assessor default to a soft tissue injury? So it actually came to a panel, and it was quite deeply discussed, and we ended up finding that there had been a not minor injury due not to a structural injury of the nerves, but to a sort of a physiological injury of the nerves, because that was the point of the original assessor. He said there's nothing structural here, but there was actually a sort of a physiological injury of nerves, where nerves were, behaving differently and giving rise to this person's symptoms. In the overall scheme of things, I would still say that in my mind, that would be a relatively minor injury compared with, someone, for example, with an extremely severe brain injury. But, we're trying to apply the definition, in a panel situation, and that's what the panel found. And there was a neurologist on the panel. It gave rise to some interesting discussions about people that get neck injuries and then get exacerbation of migraine, for example, which I had always thought should be a minor injury. But since I was on this panel, if I was asked to assess something like that again in the future, I would probably have to say that, there's been a physiological, injury to the nerves. It's not structural. You can't see it on a scan, but, the nerves are behaving differently as a result of this injury. So I take that point. I made a few notes, what I would like to say. Just one important point with the minor versus not minor injury. If an injury is resolved, it can still be not minor. So that's an important thing. So even if you found that, someone has radiculopathy, or someone else found it, or a whole bunch of doctors found it, and then by the time you see the claimant, there's no radiculopathy, you still have to find that it's a not minor injury, even though it's resolved, which does seem rather counterintuitive, but I think that's the wording of the Act, and it's different, from earlier, where if something's resolved, you can put it to bed. Another challenge I've found is that sometimes you have to deem an injury not minor, and you think really it is minor. I give an example of someone that had quite a deep laceration to their leg and had it, sutured, and then had some numbness and dysesthesia around the wound, and the original assessor, I think, said that was minor. It was challenged. It came to a panel. We had to find that it was not minor because there had been an injury to the nerve, and panel was a bit perturbed about this because overall we thought, well, this does seem minor to us because it's resolved. I mean, the person's just got a little bit of discomfort around a scar, but if you apply the definition correctly, then you really have to find that such an injury is not minor. We did put a couple of sentences in the certificate to say that the panel really thought in the overall scheme of things that this was minor, to make us feel better, because we found it rather silly that we were finding an injury that we all thought was minor. We were finding it not minor, but we were applying a legal definition. So that was interesting. Sue, did you want me to comment about the discs now, or is that coming later?
Let's come to that, because we've got some questions that have also been submitted by participants live tonight, but also prior. But I just wanted to run a comment by that's been submitted tonight. It's unrealistic to accept that by any stakeholder that a soft tissue injury is or could be minor and last 26 weeks.
Yeah, I agree with that, because mostly the symptoms are supposed to resolve. I guess the actual tissue healing should take place, depending on the severity of the injury, within a few weeks of the injury. Yep. I guess the problem is that a lot of these people that come for legal assessments, their soft tissue injury has been complicated by a chronic pain state. Yep. Which, as we know, results from changes in the dorsal horn of the spinal cord, where there are, complex neural pathways which mediate pain transmission. And chronic pain state, that's a difficult thing. But yes, the physical aspects of an injury, of a soft tissue injury, should be healed within a few weeks of injury and should not be enduring over 6 months.
Sure. Okay, thank you, Sophia. We've also got some questions around degenerative changes. Let's have a quick look first at the disc lesions.
Okay, so I'm not going to read out definitions. These pictures came from an article by Fardon, which was given to me by a colleague orthopedic surgeon during our DRS times. So essentially, just have a look at those pictures, and they tell you, or I think they show you rather, what all the various disc lesions are. I think one of the main problems with disc lesions, and it's been alluded to by other panelists, is that it's not only whether you've got a disc lesion, it's about whether you consider the disc lesion to be caused by the accident. And that is the real nub for me, because if you look at all the epidemiological data, people have degenerative disc lesions as they grow older. These findings are ubiquitous, and to you know, sort of say that every, you know, disc protrusion, disc bulge, disc whatever that you have is due to a trauma is you know, clearly untrue, and the vast majority of disc protrusions, disc lesions that we see on MRI scans in people after motor vehicle accidents have nothing to do with the car accident. And there's ample epidemiological data to show that. So it's not only whether there's a, you know, lesion present, it's got to be caused by the accident, and then, or you have to believe that it's caused by the accident, and there should also be, you know, some symptoms and possibly signs developing very shortly after the accident to make the doctor think that, you know, these lesions, signs and symptoms are causally related to the accident. You can have as many disc bulges and lesions as you like on an MRI scan, but if it's not causally related to the accident, you know, you can just say, I note this disc bulge, but or disc protrusion, and I've found that it's not caused by the accident. So therefore, you don't need to get into a discussion of minor versus not minor. I guess basically the protrusions, the sequestrations and the extrusions, you know, clearly there is a rupture of cartilage. So if you find a person, you know, has a disc lesion of that nature, and there is a good, you know, correlation of symptoms and signs developing shortly after the motor accident, then you will be finding a not minor injury. If you find, you know, a disc lesion with radiculopathy or radiculopathy without a disc lesion, you will be finding a not minor injury, providing you believe that the, you know, that these things, you know, came on due to the accident. And it's important to look at the timing. Like someone that, you know, complains of, you know, leg pain 6 months after the accident, and you find a missing reflex and some sensory loss, that's not caused by the accident. So you need to have, you know, a good sort of temporal relationship, you know, between such findings and the accident. So Sue's projected the slide here of the fissure. Fissures are also extremely common. I'm sure, notice there's a few orthopedic members here tonight, and I'm sure that they will all strongly agree that the vast majority of annular fissures are degenerative. Fissures are part of the spectrum of spinal degeneration, and the vast majority of annular fissures are nothing to do with trauma from an accident or from other trauma. They are degenerative. They are also referred to as annular tears, but I think we're trying to get away from that because a tear certainly does imply a traumatic causation. So I certainly prefer to use the term fissure because it sounds, you know, less traumatic. I think one of the difficulties is that claimants are quite often now presenting to medico-legal assessments with their MRI scan in tow. And this is contrary to the CIRA guidelines, which say that, you know, you really shouldn't be having an MRI scan for a non-specific, you know, neck or back injury, you know, from a motor accident, unless, you know, there's obviously, you know, significant trauma. You know, the accident sounds like, you know, something serious could have happened. Unless, you know, the person has, you know, neurological signs consistent with either radiculopathy or, you know, possibly myelopathy, spinal cord compression. No one's going to argue that an MRI scan is necessary in those circumstances. But for, you know, a person with, you know, non-specific neck or back pain after a car accident, an MRI scan per the actual CIRA guidance is not recommended. So the fact that we're getting MRI scans that show annular fissures and disc bulges and disc hernias, you know, after the accident, and they're bringing the scans to the appointment, that's a problem because, you know, a lot of the, with due respect to other members of the panel, some of the you know, the claimant lawyers are saying, well, here we are, we have a disc tear here, or we have a disc protrusion, you know, and, you know, this is a rupture of cartilage. it's due to the accident. But when you talk to the the person, they haven't developed extremity pain, say that might be consistent with a focal disc protrusion, touching an L5 nerve or whatever. And when you examine them, they don't have the signs of radiculopathy. So although they might have this disc protrusion there, it's not relevant. Or the disc protrusions to the left, for example, and the claimant's symptomatic complaints are on the right. So it's not just a matter of having these, findings on the scan. You need a correlation between what's on the scan and what, the person is complaining of, and of when, these symptoms and signs developed in relation to the accident.
Okay, so we're going to move to Dallas in just a moment, but I have one more question for you that relates to some of the content that you've already been talking about, and that is the question, aggravation of pre-existing degenerative changes in spine leading to surgery without radiculopathy or acute disc prolapse, minor or non-minor?
Okay, yeah, so this is my point about people minding their language. Been on quite a few appeal panels. If you kind of say things like aggravation of bony changes in the spine, or aggravation of facet joint arthropathy, aggravation of knee osteoarthritis, don't say that, because what will happen is that the claimant's legal representative will come back and say to you, but hang on, doctor, that's an aggravation of bony change. That's not a soft tissue injury, it's bony. Just use the wording that's in the Act. Okay, so if you find that there's a soft tissue injury of the spine, it's a soft tissue injury of the spine. It's not an aggravation of bony changes. I mean, you might think it is, but it's not. It's just say it's a soft tissue injury. Stick to the wording in the Act, because that will make your decision much less likely to be appealed. The minute you say soft tissue injury, it's a minor injury. The minute you start saying aggravation of bony this and that, it could become something that's not deemed to be a minor injury. So keep the language simple.
Okay, we're going to have a look at a couple of other specific questions, specific injury scenarios, but I'd like to just firstly ask Dallas and then followed by Tim. Dallas, from an insurer perspective, what are the scenarios that you're seeing that are causing the greatest challenge?
Thanks, Sue. Yeah, look, just what on Sophia was saying, a resolved non-minor injury is still a non-minor injury for the purposes of the Act, and what it translates to is a question of entitlement. The scenario I always use is if somebody has a broken leg in the motor accident, it completely resolves 5 months down the track, back at work, no treatment and care required. Then that translates to, whilst there is an entitlement for statutory benefits, there's just simply nothing to claim. So the continuation of the statutory benefits claim continues, there's just nothing to pay. What it translates for a common law damages claim, whether they're over the permanent impairment threshold is a bit of a question mark. If not, then there's no entitlement for non-economic loss. If so, if there is, then it's just an assessment for the assessor or resolution, but also if the person's broken their leg and there's no treatment and back at work, then that might translate to very little, if any, future economic loss or any economic loss at all. So on the scenario that Suncorp sees on a day-to-day basis, because the entitlement of statutory benefits is payable soon, very quickly, because of the objects of the Act to rehabilitate and provide benefits as soon as possible, it is a question of diagnosis of the injury that Richard was talking about. We need to know exactly what injury was caused by the motor accident and how that translates to a loss of earnings and a need for reasonable treatment and care. So that's the sort of scenario. The PIC have issued some directions on medical assessments. There seems to be a growing trend towards on the papers. I don't know whether it's a possibility or whether these sorts of questions could be done and assessed on the papers. I think it would be very difficult, but it's certainly an option. And the other thing is that we sometimes need clarification for when a medical report comes in from the claimant, that we might just need a review of that report just to check whether the diagnosis is correct and whether it is a minor or non-minor injury for the purpose of statutory benefits. Again, reducing the the question of what the medical expert is required for the purposes of assessing the claim.
Okay. Thanks, Dallas. I'm going to merge the next question and ask you to comment on this, Tim. This is a question that's been submitted. And Dallas also, if you could weigh in on this, what are you actually looking for from an AHP in terms of medical evidence that supports a minor or non-minor determination? Should the report include medical evidence, or should it be opinion-based based on clinical evidence? Where's the line? Maybe first to Tim and then Dallas.
I think clearly it should have medical evidence on which it's based. I mean, in terms of the spinal injury scenario that we've outlined, I hear what Sophia says about an MRI scan, but it's still one of those potential signs of radiculopathy. So I would have thought, whilst CIRA has discouraged the use of MRIs in spinal injury cases, that doesn't say if they're actually performed, they're not relevant. They are relevant to assessment of radiculopathy. One has to also be able to have sufficient evidence to satisfy oneself about whether there's a second sign of radiculopathy that's required under the minor injury test. Clinical experience, I don't think that's quite there. I think you need to expose your path of reasoning somewhat better than that, and it does need to be based on medical evidence. If, for instance, in the case of an annular fissure or annular tear, depending on what you want to call it, you decide that it's not causally related to the accident for any of the reasons perhaps that Sophia has outlined, then you need to explain why that's so, and why the possibility of it being causally related to the accident is to be excluded, particularly in a younger member of the population, let's say.
Okay, Dallas, any other comments on that?
No, I agree. Any opinion based on clinical experience, it's always helpful to rely on medical evidence, based on medical evidence. And I think Tim mentioned before that opinion needs to be as objective as possible.
Can I just say something here? I mean, when we're talking about medical evidence, I mean, I also understand that like an examination of a person is also, is that what we're also including as medical evidence, or are we specifically talking about like radiological or MRI evidence? Because
I think the question was in the context of journal evidence, studies and so on, and potentially even in the context of the Supreme Court ruling recently. But what is the expectation essentially of an AHP? We're not talking about when it, gets escalated, but, how comprehensive should the evidence be in terms of the opinion expressed in the report?
Yeah.
The procedural direction certainly requires you, that's PIC 4, requires you to make reference to that type of evidence. It's quite prescriptive, PIC 4. I encourage the assessors to make themselves aware of it.
Just while you're talking about that, something you mentioned briefly before, Tim, that I think that most doctors wouldn't know. I certainly didn't know it until you advised me in an earlier conversation last week, that the PIC, the new Personal Injury Commission, has modified the paragraph that we've all been obliged to put in all of our reports until now about code of conduct. It's basically the same paragraph, but it now has the words Personal Injury Commission or something like that in it.
You need to say that you acknowledge and agree to be bound by PIC 4, which is the expert witness evidence.
I'm sure that virtually none of our doctors knew that until we're telling them now.
I think you also need to still make reference to Schedule 7, though, because the report still has the potential to be used in the district court.
Mm-hmm.
So I think it would be sensible, and this is what I'm certainly doing in my briefing letters, asking the assessor to acknowledge both codes, which are somewhat different, strangely.
Tim, could I ask you to perhaps suggest for us the paragraph that you would suggest, the wording, and we'll put it onto the AMLC website so that all doctors will be able to have a reference of a
Sure.
symptom. Are you happy with that?
Not now.
Not now, definitely not now. No.
Don't take dictation, Richard.
No. No.
Diana, you've got a comment.
Yeah, I just want to make a comment. I just want to take up something that Mr. Kincannon said just about the criteria for radiculopathy. I'm reasonably certain that MRI findings are not part of the criteria for radiculopathy for the motor accident scheme. I have a feeling they might be for the work cover scheme, that there is one of the dot points for radiculopathy under Workers' Compensation Commission refers to, having appropriate, X-ray findings with, disc protrusions and the like. But in motor accidents, the definition of radiculopathy is confined to clinical findings. So if you've got missing knee reflex, you still need another sign of L3 or L4 radiculopathy. You need the two signs, and MRI scan findings are not part of it. And I'd just like to extend my comment further, just to say that I feel in the new scheme that there's an over-reliance on scan findings. I mean, I've had brain injury cases, alleged brain injury cases, people worried about sort of white matter ischemic change on a brain scan. That's not a brain injury. I mean, that is usually a problem to do with long-standing hypertension. And you have to explain all that in the report, why that's not a brain injury. And if they hadn't had the MRI scan inappropriately in the first place because they didn't have loss of consciousness, their Glasgow coma was normal and there were no neurological signs, so they didn't really need to have an MRI scan. Our reports would not really need to have these types of conversations. So I feel that there's quite a lot of unnecessary imaging being done at expense. Other comments, you get things like, I had one case where someone had an ankle reconstruction many years ago and there was a bit of lucency at the tip of the fibula on plain X-ray. And we had to go to all the trouble of, getting a radiologist to look at various scans to kind of say, well, there aren't signs and symptoms here of a recent ankle fracture. All this stuff, is old. So there really is excessive reliance on radiology and a lot of misunderstanding about degenerative changes, not only in the spine but also within tendons and so on, as being due to car accidents. Rotator cuff injuries are another one, very common in older people, usually not to do with the car accident. Sometimes maybe, but usually not. Things like, split tendon tears in the peroneus brevis, that was another one I saw. That's also not to do with the car accident. And these findings are being described on unnecessary radiological investigations and giving rise to a lot of, confusion and argument, between parties. The X-rays and scans were not done unnecessarily in the first place. We wouldn't need to be having these conversations.
All right, I'd like to take a slight pivot and direct a question to Clarence, Dallas or Tim, and it's just around psychiatric assessments. And we've noted that there are a change regarding adjustment disorder, acute stress reaction. Are there any other changes under the Act that pertain to psychiatric assessments of note or that are causing a particular challenge?
I think that that's one of the key friction points of the definition of the minor injury definition is the psychiatric provision. I mean, they clearly made a decision to adopt a diagnostic test for whether it's a minor injury in the psychiatric field rather than to look at the affectation of daily living as being a test. I think the problem with that is that diagnosis can shift from one diagnosis to another very subtly. And secondly, that in the case of an adjustment disorder, you've got two different breeds of adjustment disorder, an acute one and a chronic one. And I've seen any number of adjustment disorders diagnosed in MAS medical certificates, for instance, several years down the track. To say that recovers after 26 weeks is just not correct. I think that one of the problems is that these minor injury assessments have been done in the first 26 weeks, and in the case of a lot of these disorders, they just don't become apparent till well after the 26 weeks, if not a couple of years down the track. So it may be that minor injury assessment for psychological injuries, I would submit, should be done somewhat further down the track than 26 weeks, at least, let's say 12 months.
I'll just respond to that. I think I guess one of the issues Tim's raising at this issue of, primary psychological injury and a secondary psychological injury. And by that, I mean, a psychological injury as a result of the motor accident. So, a traumatic event happens and you have a psychological reaction because of the motor accident is what we would describe as a primary psychological or psychiatric injury. My understanding, and, participants who perhaps a psychiatrist might be able to correct me if I'm wrong, but is that, a lot of conditions, with some exceptions, should manifest themselves, fairly in a reasonable short period of time after that traumatic event. And I don't think that it necessarily requires that kind of 12-month timeframe that Tim is referring to. On the issue of secondary psychological injuries, where I guess we're talking about a situation where somebody develops a psychological injury, not because of the traumatic event of, say, the motor accident, but because perhaps the consequences of their injury, a physical injury, say, causes them to have a psychological injury. And now that obviously can develop later on, depending on the person's reaction to the evolving circumstances. I guess the challenge in the way the minor injury definition is framed is that, so if we're looking at people who have more than soft tissue injuries, obviously it's not going to really matter for them because the minor injury definition is already passed for them. They've got more than a soft tissue injury. So whatever their psychological or psychiatric diagnosis is, it's not really going to have an effect on their entitlement. So we're really only talking then about soft tissue injuries. And if we're talking about soft tissue injuries, then the question becomes, well, if you accept that, that I guess that chronic pain and suffering can lead to a psychological injury, at the moment, that obviously isn't accounted for in the minor injury definition because adjustment disorder, is specifically included as a minor injury definition and the person has a soft tissue injury. But I guess the challenge is that if you accept that can happen in a soft tissue injury, then obviously it's going to have consequences for a whole lot of, of people who have soft tissue injuries, which the legislation is designed in a way that the typical response for a lot of those injuries is that people will recover because they're not supposed to be serious injuries.
Well, as Clarence dealing with that, I'm aware of a couple of cases where adjustment disorders have come in above 10%, are disabling nearly 3 years down after the accident, and horribly debilitating. Yet are being the insurers attempted to argue that it's a minor injury because it's now an adjustment disorder, and it's just I just see adjustment disorders being diagnosed on a regular basis several years down the track.
But I guess I would ask the question for me, Tim, then is what are the circumstances? Is that related to a soft tissue injury or is that related to a more serious physical injury, or are we talking about a primary psychological injury?
I think it's a primary one in that case. This is a case that was brought to the attention, I think, serious attention by the ALA. I think you might be aware of it.
Yeah, but if it's a primary psychological injury, then I think then the question becomes: is adjustment disorder? And again, I'm not a psychiatrist. I would leave that up to the experts, and I would appreciate any comments of anyone online who can say this. But would adjustment disorder, is that even available diagnosis that far down the track for a primary psychological injury? I understood that it wasn't. That after a certain period, I think 3 or 6 months, that by definition it's not an adjustment disorder.
DSM-5 doesn't say that, Clarence. I think you'll find the psychiatrist will. Well, so do that.
Yeah, well, I certainly
There
appreciate
are
it.
two forms of adjustment disorders.
There's a lot of complexities around this issue of minor versus non-minor. I think we've heard a number of scenarios now where there seem to be obviously complications around, does the injury fall into minor or non-minor, and should it, is the definition actually correct? And there's been a whole host of questions that have been submitted prior to this webinar and on our live chat. So what I might ask is that for our panelists, we can distribute the questions. We'd love to have, I guess, a cross-section of feedback on some of the questions that have been raised by our panelists. I'm very conscious of the time where we're at now, and I wanted just to skip to a question that that is also has been submitted to us prior to this webinar. This is one that has been raised, and Richard, for you, that I'd like to go to you for, and that's a question around the appropriate use of specific specialties when conducting motor vehicle assessments. Richard, could you elaborate, please, just in our final few minutes of our webinar, what is the basis of the conversations?
Yes, good. Thank you, Sue. It actually arose because of a workers' compensation, New South Wales workers' compensation guideline instruction, or it's a guideline, section 7.2, and it effectively says that, sorry, I should have put it in front of me, that the appropriate specialist must be used for certain sorts for all injuries for assessments. And that's, of course, very reasonable. However, the referrers, a number of referrers in the workers' compensation, and we've experienced a similar sort of thing in CTP as well, a number of the referrers read that to mean that only orthopedic surgeons can undertake musculoskeletal injuries. And a lot of other doctors, including orthopedic surgeons, feel that that's incorrect. For example, of course, if the questions also relate to earning capacity, work capacity, to domestic assistance, paid domestic assistance, etc., or generally, if the question is about diagnosis, obviously an orthopedic surgeon is very skilled in many fields, but the primary difference between an orthopedic surgeon and other doctors who look after musculoskeletal injuries is the use of a scalpel, is the operative skills. Now, I'm not suggesting that that's the only skills of an orthopedic surgeon, clearly not, absolutely not, but that a lot of other musculoskeletal specialists have skills in the majority of sort of injuries we see. And in fact, the concept is that many of the injuries we see, if it were not compensable, would never be sent to a specialist at all, because a general practitioner will look after many of the conditions that we see. So the question that we wanted to raise with our panelists is the misinterpretation that a number of people have seen, that musculoskeletal injuries should all be referred to an orthopedic surgeon. Do the panelists have a comment on that?
Might lead with Clarence.
I mean, from a serious perspective, that, you know, really the specialist just has to have appropriate skills and qualifications to the issue. It doesn't necessarily have to be, you know, a specific, we don't prescribe any specific classes or specialties. There was a case recently, actually earlier this year in January in the Supreme Court, where this kind of issue came up actually in the context of the 1999 scheme and a medical appeal panel that was set up as part of Syria's former Motor Accidents Assessment Service. And the claimant in that case objected to the composition of the panel because they can argue that they had a kind of a condition that should be sort of, I guess, the exclusive domain of opinion by a neurosurgeon, and there wasn't a neurosurgeon on that panel. And the court looked at that issue and said that they didn't think that was, they didn't find error in the composition of that panel. The panel did include an orthopedic surgeon, I think a rehabilitation physician and a GP. And the court essentially said, listen, you know, these kind of things, they're fairly arguable points. It's not completely unlimited. There's a spectrum, and you need to consider it based on the condition and what's appropriate. And they used like an extreme example and said, like, if in this case you had a plastic surgeon, a urologist, and a psychiatrist, it's probably not appropriate. But they saw no issue with the composition of that panel. So, I mean, while that doesn't provide a definitive answer, it does provide a guide that the law sees that there is a spectrum of specialties that can look at this issue, and really the question is going to be one of appropriateness.
Dallas, in-house from an insurer perspective, how are these conversations managed? Is there any particular guidance provided to your teams?
There's nothing concrete, but we're sort of heavily guided by historically what the medical assessment service in the MAIA scheme would refer a specific medical question to an expert, and quite commonly a permanent impairment of a physical injury was referred to an orthopaedic surgeon, and that seems to have been adopted within the insurance company. Similarly, for a psychological injury, it was commonly sent to a psychiatrist. So it's nothing concrete in answer to your question.
Dallas, Tim, sorry, from a legal perspective, you probably have a view on preference. How would you manage that scenario?
Again, I think it depends on the case. There's a place I think for both orthopaedic opinions and for occupational physicians. If the crux of the question is really issues of earning capacity, then I think definitely an occupational physician tend to provide a more detailed opinion on that aspect. If, however, even in the case of earning capacity, deterioration in an orthopaedic condition and the likelihood of future surgery, which might take the claimant out of the workplace for a period, is relevant, then I'd be certainly looking at an orthopaedic opinion either in lieu of or as well as an occupational physician.
Okay.
Can I just make a final comment, and it's probably going to be the end of the webinar, and that is that of course, there are many other sorts of specialist types, such as rehab physicians, such as Sophia is, and sports physicians, and many others who look after the same sorts of injuries, neurologists, neurosurgeons, and multiple sorts of specialists. So that's the first thing. Secondly, one of the greatest skills and expertise in undertaking IMEs is to actually understand what the system's all about and how to address forensically, and that's the word I've used several times tonight, forensically the issues. And that sort of training comes, for example, and I'm just going to do a little plug here, but it wasn't intended, this is not the reason I asked the question, but Australian Medico Legal College has a whole training program on how to take IMEs professionally, objectively, and comprehensively, looking at the issues that need to be answered, that offer the data that the referrer needs, the raw data on which they can make their decision. So there's a whole other skill besides the medical skill that goes into doing IME work that lots of sorts of doctors, surgeons, I left general surgeons out of this as well, many other doctors, but the biggest skill of all is to actually understand how to do IMEs comprehensively and professionally to be able to answer the questions properly. We were going to ask a couple of polls. We clearly haven't got the time to do that now. We're going to put those questions to our viewers, but we haven't got the time. Was there anything else, Sue, before I wrap up, because we're running out of time?
Look, no, I think it's time to wrap up. We promised to be finished by this time, 2 minutes time. But I just wanted to thank everybody for all the comments and questions and acknowledge the depth of the questions that have come in. There's so many other topics around pain and all kinds of the interplay between medical and legal, etc., that we would love to touch base on, and we'll follow up with after this webinar. Thank you for submitting those. I'd really like to thank you for those, but I guess it also shows how important and how much interest is in discussing the environment that you're operating in. Sorry, Richard, over to you.
Okay, look, thanks, Sue. So just to wrap it up, our role as IME consultants is to provide medical data from which non-doctors can reach balanced administrative and legal decisions. However, to provide the requested information requires substantially more time and forensic skills than many might presume. Australian Medico Legal College is a not-for-profit educational college with a training syllabus, including many videos for trainee fellows of the college, and we welcome everybody's inquiries. Our email's going to be on the screen now, Sue, thank you, which is that's the one. And below you'll also see the MedDirect website as well, because that's relevant, because this webinar tonight has been recorded and will be available free on the Australian Medico Legal College website and on the MedDirect website as well in the next few days. Tonight's poll result, and there's only one of them as it turned out, will be published and available in a few days' time. And I think it'll be of interest to all sorts of people to look at that. Just to mention also that it'll be available on the MedDirect email website as well. MedDirect has advised Australian Medico Legal College that their website has many free quick video tutorials to help doctors to run their own medico-legal practices. I'd like to advise everybody that our next webinar will be in approximately 6 weeks. The topic yet to be decided, but it'll be probably more directed towards a pure medical, as in medico-legal issue. So on behalf of Australian Medico Legal College and of all the members of the other medical colleges who joined us tonight, I'd like to thank you, Clarence and Tim and Dallas and Sophia, immensely for your time, effort and perceptive insights into these relatively new concepts that many of us are increasingly encountering. I'd also like to thank you, Sue, and MedDirect for your extraordinary time and energy in facilitating tonight's webinar. Using your skills as you've created a medico-legal practice management system that enables IME consultants to manage their own medico-legal work directly. And most importantly, I thank you, our audience, for your attendance tonight and for the many, many questions and comments that you've submitted, which we'll be answering in the next few days. We thank you all again for your interest and involvement. So good night, everybody. Thank you.